All right, good afternoon. Welcome to this session of Iowa Court of Appeals Oral Arguments. I am Judge Chikelli, and it is my privilege today to be presiding with my colleagues, Judges Buller and Langholz. Today we will be hearing three cases. The first case is case number 250172, Kevin Koeller, appellant, cross appellee versus Cardinal Logistics Management Corp. And Ace American Insurance Co. Appellees cross appellants. The appellant is represented this afternoon by Attorney Joseph Powell, and the appellees are represented by Attorney Patrick Mack. All right, at this time, counsel, are you ready to proceed? Yes. All right, whenever you're ready.
Please, the court. Counsel. This is an appeal from a decision of the Iowa Workers' Compensation Commissioner, where the commissioner adopted the opinion of an expert and then modified and changed that opinion based on the commissioner's own understanding and experience and expertise with the guides to the evaluation of permanent impairment.
Was it really based on expertise, or was it more based on what the statute said to do?
Thank you for your question. The statute requires two things. One, solely use the guides to the evaluation of permanent impairment. And two, do not utilize agency expertise when determining extent of permanent impairment. So the statute requires the guides to be used, specifically the physicians that provide the impairment ratings on any given case must use the 5th edition of the AMA guides to the evaluation of permanent impairment. Then the next question is, okay, what is the extent of that impairment? That question lies solely within the domain of expert opinions. That is what the code section says. Agency expertise cannot be utilized. The guides themselves in their plain language require that a physician provide the impairment rating. So when you look at that in tandem and you look at Iowa Code 8534-2X and you interpret it, you're going to see those two things. Use the 5th edition of the guides and keep agency expertise out of this decision. However, that's not what happened in this case. In this case, there was two expert opinions that explained exactly how it is you are supposed to use the AMA guides to the evaluation of permanent impairment. Dr. Taylor and Dr. Kreitz. The agency ultimately adopted the opinion from Dr. Taylor. But then they decided that that needed to be modified based not on any opinions that were actually in the record. Rather, based on other cases where other experts were involved and gave opinions in those cases. The commissioner, in his job, reviewed those cases, reviewed those expert opinions, took those opinions, used them as his own, and inserted them into this case.
Wasn't, as I understand the commissioner's decision, I mean, it relied on Dr. Koeller's and his testimony that he was deviating from the guides, that there was a mistake in the guides. So how do you, one could say the commissioner was following the guides. It was the expert that was trying to add some other expertise in there. How do we wrestle with that?
The best person to determine whether or not there was a mistake made is an expert. Who else is responsible to determine whether or not the guides were properly followed? You look at expert opinions. You look at their explanation. You see what happened. Like, okay, did they follow the guides? And in this case,
He wasn't following the guides, that that his training said we shouldn't, this was a mistake in the guides.
quite the opposite. There is an exact explanation from Dr. Taylor that says, I see how someone might be confused. If you only read the first sentence of the introductory paragraph of the guides, you skip over the pages in between, and then you look at this applicable table, you could make that mistake. Problem with that, of course, is the table itself, if you look at it, says to use a 10% impairment rating. Then the guides, as they so often do, provide examples. Here's how you use this table. And the examples of the guides for exactly how you use that table, they don't apply any kind of modifier or reduction. Dr. Taylor explained that in pretty good detail in his report, saying if the table itself says don't use it, I understand how you get confused. He also elaborates that if you read past that first sentence, and you don't just skip to the end, you're going to see something. Every time there is a table where you are supposed to apply a modifier, you're going to see an asterisk. And then the asterisk below the table says, apply a modifier. What you don't see in this table at hand, which is 1627, as well as others, is there's no asterisk. And if you look at the examples of exactly how you're supposed to use the guides, they don't modify it. So what the commissioner did was look at a different expert opinion that read that first sentence, missed everything in between, looked at the table itself, and inserted that sentence into that table, which conflicts with both the table and the guides themselves for how the table is supposed to be used. We have clearly crossed over into agency expertise here. If this decision stands, we're kind of left with an option from a practitioner standpoint. If the commissioner is going to himself or herself be allowed to determine the best way and the proper way and the expert way to apply the impairment ratings, what we are going to need to do is get impairment ratings from doctors on any given case, claimants and defendants, and then essentially offer them to the commissioner in advance of hearing to see if he is going to rebut them and get his take on it. And then maybe even need to depose him. Take that deposition transcript, share it with our own experts to see if the commissioner is correct. That's essentially what I did in this case, although I didn't have to depose the commissioner because I was aware of his prior decision of Jay versus Archer skid loader, where that is what he did. But I shared that with Dr. Taylor and point blank asked, is this medically, technically, expertly the correct way to do it? The answer is no. And again, his explanation is, I see why you're confused or why you might have believed that, but look closer. Read everything. Apply the tables how they're supposed to be applied, and you're going to come to the result that I come to, which is it's a full 10% impairment rating for that procedure, and there is no modifier being used.
What do you think the guides are? I mean, what sort of, are we doing a legal review or a factual review? And I'll have some follow-up. To start with that piece.
Because it's almost like a mixed question of law and fact. I mean, we've got Iowa Code 8534-2X staring at us. That's got to mean something. We have to interpret and apply that. That's legal. So then the question is, factually, then what is the deputy commissioner or commissioner supposed to do? Look at the impairment ratings from the doctors. Look at the medical records they reviewed. Did they review everything? Did they have all the necessary information? Make sure they followed the 5th edition of the guides. Sometimes you can get impairment ratings from doctors that come in and reference 6th edition, 4th edition. Nope, by law you can't do that. So factually make sure they're using the appropriate portion of the guides. Then make sure perhaps you're using the right tables for the right body parts that are injured. If someone has a wrist fracture and the expert who offered an opinion is giving impairment for like a cervical spine issue, you've got a problem. I think as a fact finder, you can come in there and address that and change it or modify it or outright reject it. But what you can't do is once you've determined, okay, this expert had the appropriate medical records, I like the physical examination, it's well documented, I can follow along, they're citing these charts, these tables, those are correct for this body part that's been injured, we're good. But don't take that next step, and now let's look at extent of permanency, and I'm going to insert my opinion about the best way to do it pursuant to the guides. That's where we come into a legal issue, and that's what you can't do.
How do you draw that line? I mean, I think I heard you say, but if I didn't, correct me. I mean, that if there was a clear misapplication of the guides, that the commissioner could see that and take that expert's report and adjust it to correct the clear misapplication of the guides. Is that correct?
I believe so. And it would, of course, be a case-by-case, fact-by-fact situation.
Where's the line kind of between when it's a clear misapplication of the guides and one that we're bound to what the expert said?
And kind of reiterate what I said earlier, if the expert's clearly using the wrong table, clearly using the wrong chapter, talking about a body part or a fracture to a femur rather than some other body part that was supposed to like a clavicle or something, you can look at that and be like, hey, I can step in here, I'm within my rights to look at that and maybe outright reject that expert's opinion or modify it. Or let's say you have an expert opinion for a carpal tunnel case, and the expert provides an impairment rating to the hand. carpal tunnel is actually an injury to the arm, I think the commissioner would be within their right to look at the impairment rating that was given by a physician to the hand and then convert it to an impairment to the arm. And there's a way you can do that in the guides. And that's pretty clear. You know, you can see almost like a scrivener's error, if you will, or something that, hey, I understand what you were doing. From a legal standpoint, that's the wrong body part. We're going to convert this, and there's tables in the guides that allow you to do that. And you wouldn't be getting in there and necessarily rebutting any expert's opinion about the proper way to do it. It would just be a factual and legal adjustment to the claim.
In this case, does it come down to whether we agree that with your interpretation of the guides, I mean, is it essentially a kind of like a correction of errors at law? You know, that we're just, you know, was the commissioner right in how he was reading the guides, or was the expert right in how he was reading the guides?
I'd like to be able to answer your question unless you want me to hold off on that.
Answer the question.
Again, it's up to the experts to decide. In this particular case, because of the expert opinions that are involved, you cannot legally go beyond those and reach outside of the evidence in the record and adjust that impairment rating.
Thank you, Counsel. You will have 5 more minutes on rebuttal. Counsel, are you prepared to proceed?
Justices, may it please the court, my name is Pat Mack. I am here on behalf of the appellees in this case, cross appellants as well. To address the argument made by the appellants, I think it probably, at least in my opinion, is clear from the record that it is, in fact, common in the AMA guides to use that 2.5 or 25% modifier. Dr. Taylor would not have needed to actually go into specifics into terms as to why he doesn't believe, in my personal opinion, that in his education, training, and experience in application of the guides, that the modifier should not be applied. This is something that the commissioner determined that the modifier should be applied based on the AMA guides. The appellee's position on that would be that that is a factual issue or a factual determination by the commissioner, which generally is not disturbed on appeal. When it comes to the cross appeal, Your Honor, I think the primary issue has to do with the award of alternate medical care. And that would be because in this case, we have a shoulder injury, undisputed shoulder injury. And then during the course of medical treatment, there was a recommendation of a evaluation of a brachial plexus injury. Now, the only body part that was pled in the petition for arbitration was the shoulder. There's no mention of the body as a whole, the brachial plexus, anything that would include that body part. Now, I guess the confounding thing, or one of the issues that needs to be addressed, is if anything extending outside the shoulder is, not, if it wasn't pled or included in the hearing report, should have been an irrelevant issue to be decided by the deputy commissioner. The brachial plexus in the Chavez cases, where the Supreme Court has defined the shoulder, has not made any mention whatsoever of where the brachial plexus is within the body. And I believe in exceeding their authority, the deputy commissioner failed to address that in her decision, primarily because she had just made the decision that it was related to the shoulder, but never addressed anything on the application of why it should be considered part of the shoulder injury under Chavez and Dang. And that was admittedly absent. It's the appellee's position that the brachial plexus is in fact part of the body as a whole, so the the deputy commissioner would have exceeded their authority by awarding a body part that was already stipulated to not being at issue at trial. And so, the appellee's argument in terms of the brachial plexus being part of the body as a whole is actually based on the same treatise that was used by the Supreme Court to define the shoulder in Chavez in the Amjur proof of facts. If you look at that section dealing with the brachial plexus, you'll see that the nerves that generate into the brachial plexus are actually generate from the neck. And I believe with the injuries that Mr. Koeller had sustained, it most likely would have came from C3 or C4 vertebrae, because he was having issues with pain and numbness all the way down to his fingers. And of course, it is an issue, I believe, that is supported by current case law as well. The essential function of the shoulder, as is addressed in Chavez, is just the nerves, the tendons, the muscles that comprise of the shoulder. It doesn't extend onto that. Absent from Chavez and Dang is any mention of the brachial plexus, of course, probably due to judicial avoidance. And it, however, was not extended in any manner in which the deputy commissioner decided it. Again, the appellee's argument would be that it should have been addressed by the deputy commissioner regardless. And that was an issue. I'm guessing it was something that will be brought up on rebuttal, but that is an issue that was before the agency prior to the district court's ruling, which would make it applicable to this particular appeal. The denial of benefits based on, or the denial of alternate medical care was based on causation. Did it specifically mention the brachial plexus in and of itself? No, but based on prior case law, I think it's in Ochoa, as long as the defense is made in some manner, it doesn't matter if it specifically cites the statutory authority that is at issue or used by the defendants in a later proceeding. That issue was definitely in front of the agency in a manner in which both parties had an opportunity to address it. It is treated probably most extensively in the brief of the appellees to the commissioner. And based on my recollection, I do not believe that particular issue was addressed whatsoever by the appellants. So
back to the paragraph X issue on the first appeal. I mean, what's your position of how we should review the guides? Is this a legal question where we're deciding whether the commissioner was right about the application of the guides or the expert was right about the application of the guides, or do we need to give deference to one or the other of those decisions? What is it, law or fact or something in between?
I do think it's a factual issue. I definitely understand the appellant's position that it could be a mixed issue of law and fact. The issue here, though, is in the matter of fact is that the commissioner or the agency has to adopt the use of the AMA guides. They're not allowed to look outside of it. The problem that we do have here in both J and in this particular case is really, I would argue that Dr. Bolyer's impairment rating is in accordance to the AMA Guides 5th. However, if you were to assume for the matter of argument that it is not, you have a situation where arguably none of the ratings apply with the guides. Not even the rating that was addressed by Dr. Taylor And I think Jay actually does a pretty good job of saying why there needs to be some sort of wiggle room in this whole situation, because absent the court having a rating on the AMA Guide's fifth, they aren't allowed, or they don't have to they basically essentially disregard it. The fifth, as appellant had pointed out, is the only version of the guides that can be used. And if none of the ratings in the record apply with the AMA guides, one might take the position that if the deputy is not allowed whatsoever to modify that rating, that the injured worker is entitled to no permanency whatsoever, because all three opinions in this case, and of course, again, for the sake of argument, with Dr. Bollier, would not apply to the guides, so there would be no evidence in the record that the permanency based on Iowa law would be awarded. I think that that's definitely something that is not intended by the act. Of course, it's supposed to be interpreted liberally in favor of the injured worker within reason. And it's difficult for the appellees to understand exactly how a modification like the commissioner made in this case, or the deputy commissioner made in this case, and then of course the commissioner made in J, wouldn't be appropriate based on the statutory construction. There has to be some modification to it in order for the rating to be awarded under Iowa law. And I'm out of time with that. If that's
Yep.
All right, whenever you're ready.
I would like to again say that my appeal of this issue, the only issue I have appealed, is a legal issue. It is, how do we interpret Iowa Code 8534-2X? There's no factual issue at play in the exact thing that I am appealing. We don't have any cases from the Court of Appeals or Supreme Court that deal with this statute and my exact issue I'm appealing, or how to interpret it. So this will be the first time it is interpreted. That has got to be a legal question. The interpretation of the law is not the job of the commissioner. It is the job of the Court of Appeals and the Supreme Court. And in situations like this, I'm asking you judges to read that statute. Look at its plain language. Look at what it says, and then determine, did the commissioner violate that statute? When you do that, you're going to see the answer is yes. Again, when you have a specific expert opinion that says, hey, here's on this exact issue, table 1627 in the guides, I understand there might be confusion about whether or not you should or should not modify it. You should not, and here is exactly why. Look at the plain language of the guides. Look at the examples in the guides. Read the entire section and look at what the guides do. If you do that, let's pretend like we were interpreting the guides as a statute. Read the whole thing. Don't just read the first sentence and then skip to the last. If the statute at issue is 1627, what does that table say? It says use 10%. Okay, then we go a little further. There's some annotations there. There's an example. Here's how you use it. They don't use a modifier. The only way you get around the clear language in the guides and the clear language in the law is to take the first sentence, skip everything in between, don't read the examples, don't look closely at the table, and apply it. I don't know why you would do that, but that is what the commissioner did here. If the guides were somehow incorporated into the code by reference to them, and we did need to interpret them, we would certainly give them the words they use their plain meaning. And if there was somehow some ambiguity to them, maybe it could be done this way where we reduce it. Maybe if we're applying the guides as a law and it could be done a different way that keeps it higher, well, then we do it liberally for the benefit of the injured worker, and that's going to mean no reduction to that impairment rating. For my take on this, you don't even need to get that far. You can just look at the book, read the page, and do what it says. And you would reach the same result that Dr. Taylor did. He obviously elaborates much further into medically and expertly. Here's why you don't do that. And again, in this case, then the commissioner comes in, says, yes, but I've looked at other experts who weren't experts in this case. I've decided other cases. And based on this information that I have obtained in doing this, and my expertise in this area, I can go in there and modify your expert opinion. That just cannot be the way it is done. And on its face, those actions violate Iowa Code 8534-2X.
Can I have you pivot and address the cross appeal for a moment?
Yes, absolutely. As to the alternate care issue, as I stated in my brief, I don't think error was ever preserved. We went, Cardinal Logistics put all their eggs in the causation basket. Deputy Commissioner made a determination on causation based on the expert reports and medical records and the record. It went against Cardinal Logistics. On appeal, for the first time, they have taken the position that in reality, the Deputy Commissioner had no authority to rule on that issue. If that issue was going to be raised, it needed to be raised with the Deputy Commissioner. As a result, on appeal, there was no decision for the Commissioner to look at, no decision for the District Court to look at. There's nothing to review to determine whether or not it was done correctly or not, because the issue was never raised. Therefore, we don't have preservation of error. Then the argument, which gets medically complex, into Cardinal Logistics' opinion about what body parts are actually involved here and what was injured, none of that stuff existed for the Deputy Commissioner to look at. These are kind of pseudo-expert opinions that are being offered, citing to texts and opinions that aren't in the record, and an invitation to the court to make a new fact-finding about what body parts were actually injured. You cannot do that. More importantly, he hasn't even had the treatment that was ordered yet. Once we go down that road, we actually get some treatment, we get further diagnostic tests and some medical opinions, then we'll know what body parts are involved. But right now, we're not even there. Thank you.
And that will conclude our arguments on this case. Thank you both for your briefing and for your arguments this afternoon. We will consider this matter submitted, and we will issue a ruling as soon as we are able.